Dear students, now I am giving dictation from Indian Law Reports, passage number 3. The outlines for the difficult words and phrases you can see in the description box. Now I will give the dictation. Get ready for the dictation. Start. A. The protection under Section 197 to a person who was a public servant at the time of commission of the offence but has ceased to be so at the time when the court proceeds to take cognizance of the offence against him would depend upon the nexus between his actions and the discharge of official duties. Whether such acts formed part of duty will entirely depend on the facts and circumstances of each case. B. By virtue of the provisions in the General Clauses Act 1897, the expression government used in Section 197 Criminal Procedure Code would mean the governor, and hence the contention that the locoyucta is not a public servant as considered under Section 197 Criminal Procedure Code, for he is not capable of being removed by government, is not wholly correct. It is also plain that no prior sanction to prosecute the petitioner is required under Section 19 of the Prevention of Corruption Act, as the petitioner has resigned from office, nor is a prior sanction required under Section 197 of Criminal Procedure Code. Criminal Procedure Code 1973, Section 482, offense under Section 304 within bracket capital A of IPC, submission of B final report by the police, protest petition filed by the complainant, learned magistrate taking cognizance of the offence, recording of sworn statement of the complainant, registration of a criminal case, and issue of process order passed by the learned magistrate, confirmed by the revisional court. Challenge 2. Held. A protest petition is a complaint and to be tried in terms of Chapter 15 of Criminal Procedure Code. In the absence of any ingredients of the offences alleged in the protest petition, taking cognizance is based in law. B. In the protest petition filed by the complainant, there is no detailed description with regard to factual aspects of the case as to how the offence under Section 304 within bracket capital A of IPC has been committed by the accused, and what are the necessary facts that constitute offence under Section 304 within bracket capital A of IPC. The entire protest petition contains the allegations against the police that the police have filed B final report without recording the evidence of the necessary witnesses and examining the documents, etc. Therefore, in the absence of any ingredients of the offences on facts alleged against the petitioner in the protest petition, the learned magistrate ought not to have taken cognizance for any of the alleged offences. C. It has to be borne in mind by the learned magistrate that he is not taking cognizance against the accused, but he is taking cognizance only against the offence at that particular point of time. If there are no facts constituting any offence, learned magistrate does not get any jurisdiction to take cognizance. If he has no jurisdiction, without there being any factual matrix, he cannot permit the complainant to proceed to furnish the sworn statement before the court and proceed to issue summons to the accused. These basic principles have not been adhered to by the learned magistrate, and it appears he has not meticulously looked into the protest petition, but he was fully persuaded by the contents of the B final report. It appears he read the first information report lodged before the police and the investigation made by the police into the protest petition so as to fill up the gap in the protest petition, which is not permissible under law. Further held, A. The learned sessions judge has also not bestowed his attention so far as the legal lapse committed by the learned magistrate is concerned, and he also did not look into the protest petition in a proper perspective so as to ascertain whether the learned magistrate has committed any legal error in taking cognizance and issuing process against the petitioner. Therefore, the order passed by the learned magistrate as well the sessions judge are not sustainable under law, and the same are liable to be quashed. Having come to such conclusion, it is duty of the court to see whether the court can permit the complainant to file second protest petition or additional protest petition or a private complaint, once again on the same factual aspects. The law does not prohibit filing or entertaining the second complaint or even second protest petition before the court in order to administer complete justice between the parties and opportunity to be given to the complainant to file necessary additional protest petition or by means of private complaint to bring the factual aspects before the court in order to enable the court whether it can proceed against the accused or not. B. It should also be borne in mind that in almost all the cases where B. Final report is filed by the police, the learned counsels appearing for the complainant would prepare the protest petition. For that reason only, the parties would go to advocates for their legal advice, and if any serious mistake is committed by the counsels in preparing protest petition, the parties should not be penalized for the same. The party may not be knowing what is meant by protest petition and what should be the contents of the protest petition. Therefore, it is the fundamental duty of the counsel appearing for the parties to examine legal consequences of filing of the protest petition and how the protest petition should be, and that is why he is called as legal luminary who can assist the parties. Matter stands remitted to trial court to proceed in accordance with law. A note here, the word cognizable. Most of them they pronounce it as cognizable. The outline you can write KJN surplus B upward. But it is a word derived from French word connaître, that means to know, to have knowledge. So it is pronounced as cognizable. So I have given both the outline.